Bayo, welcome. Thank you very much for joining us.
Thank you for having me.
So, Bayo, I'd like to ask what the legal implications might be for the Supreme Court disregarding the appeal by the state speaker and the Attorney General. What's your take on that?
The legal implication is simple. They have to go back to the Court of Appeal and finish up the substantive suit. Now, for the purpose of our viewers, let us explain what has happened there, what played out at the Supreme Court. Odili got an order restraining EFCC from probing him or probing his administration at the Federal High Court in 2007. EFCC, perhaps they found new evidence or something, approached the Court of Appeal to seek leave of court to appeal against that decision. Okay? So it's an interlocutory appeal. What do I mean by interlocutory appeal? That's an appeal you file pending the final determination of a suit. That means something is still going on at the lower court. You just want the appellate court to quickly consider an issue that came up during the pendency of that suit. Now, we got to the Supreme Court with an application to seeking leave to appeal against that ruling, granting EFCC the right leave to appeal against the decision of the Federal High Court. Now, let us address it jurisprudentially and in accordance with the provisions of the rules as well. Or should I say judicial procedure? First, judicial procedure. This kind of application that the Attorney General filed at the Supreme Court is at the discretion of the court, whether to grant it or not. It's not as a matter of course, not as a matter of right, not something you file and the court will just grant. It's not automatic. It's at the discretion of the court, because application of that nature, the court has to consider whether you have presented facts that will enable the court to grant such application. So it's at the discretion of the court. That's the judicial procedure aspect of the issue. And the Supreme Court has exercised its discretion not to entertain such appeal, trivial appeal. Why do I call it trivial? There's still a substantive suit that is going on at the Court of Appeal. That's the legal implication that you asked about. They are going to go back. So that's exactly what Justice Okoro, my Lord Justice Okoro at the Supreme Court said. They go back to the Court of Appeal. Let them file their appeal properly at the Court of Appeal. Then you can now respond to that appeal by filing your response and let the Court of Appeal determine that suit on its merit, whether or not the Federal High Court had the power or whether or not the Federal High Court acted in accordance of the law to have granted such perpetual injunction restraining EFCC from probing the administration of Odili. So the jurisprudential rationale behind such decision is that such would deter those kind of frivolous appeals. These are matters that concerns the entire society. Whether Odili is innocent or guilty, I think the people of Rivers State, they have the right to know.
So can the EFCC now proceed with its investigations of the Odili?
They have not even reached that stage. As far as I'm concerned, the leave that the Attorney General is seeking at the Supreme Court is premature. They have not even reached that stage. They just got leave to appeal against an order of the Federal High Court that restrained them from investigating Odili. Do you understand what I'm saying? They got an order restraining them from investigating Odili. So they want to appeal against that order for the court to determine the legal issues in that order, whether the court was right, whether that decision of the Federal High Court will occasion miscarriage of justice, whether it's in accordance of the law and procedure. Do you understand? So they've not even reached that stage. There's a law for the Court of Appeal to still determine in that suit. But you rushed to the Supreme Court. Now, if you look at it, even the lawyer that filed that kind of application should have read the new practice direction. Maybe he read it and maybe he decided to ignore it. Supreme Court has frowned at that kind. The era of technicality has gone. That's gone. Let us determine suits on the merits. And like I said, the jurisprudential background to this kind of issue is for us to look at the implication it will have in the eyes of the members of the society.
So what is that implication that might be carried on after these processes or lack of processes now?
If the Court of Appeal finds that EFCC has the right to investigate the former governor, Peter Odili, and if the Court of Appeal sets aside that order, EFCC has the power to resume investigation of Peter Odili, to look at his administration, to see how they handle the fiscal issues of Rivers State. EFCC has the right. So now, that decision will now be a final decision against, it will now be a final decision against the judgment of the Federal High Court. So if they now want to appeal at against that ruling or that decision, that final decision at the Court of Appeal to the Supreme Court, nobody will stop them, because that appeal is a final decision. It's not interlocutory anymore. That's exactly what Supreme Court is telling them. Don't rush when the house is not burning yet.
Well, Mr. Bayo Sanni, I want to say thank you very much for giving us your expert opinion here on this matter. Thank you.
You're welcome. Thank you very much.